Hello, welcome to the virtual Hammer Museum, coming to you live from Los Angeles. I'm Claudia Bester, and I'm the Director of Hammer Public Programs, and I'm pleased to welcome you to today's Hammer Forum on the recent Supreme Court decision affirming the rights of LGBTQ workers under the law. Before we get started, I have a few notes for the audience. This program is being conducted via Zoom webinar, and in a Zoom webinar, we cannot see you in the audience and we can't hear you. So we can just see your names and anything you type into the chat box and in the Q&A box. We'd love for you to all introduce yourselves in the chat box and tell us where you're tuning in from. The chat's also an area where the audience can all talk with each other. And the Q&A box is where you type in questions you have for the panelists. Please note that this program is being recorded and will be available later on the Hammer website. Also, if you'd like to receive reminder emails about upcoming events, please sign up for our email list on the Hammer website. And you can also find recordings of most of our past public programs on our website as well. So on to today's program. The Hammer Forum is a monthly series of public discussions about current social and political issues, and it's made possible with support from the Rosenblum family. We're about to do a whole series of Hammer Forums looking at really important Supreme Court decisions that are being released in the next few weeks by the Supreme Court. So as they come out, we're going to have forums and discuss what they mean. In today's forum, we're going to talk about civil rights for LGBTQ people in the workplace and the recent Supreme Court decision that upheld these rights. 9 days ago, on June 15th, the US Supreme Court held that the 1964 Civil Rights Act protects gay, lesbian, bisexual, and transgender employees from workplace discrimination on account of their sexual orientation or gender identity. Justice Neil Gorsuch authored the historic ruling. So one thing we want to discuss tonight is how the relatively conservative Supreme Court came to an arguably liberal conclusion. And also, how did this case come to the Supreme Court in the first place, and what was the legal basis of the court's decision? Our guest speaker today is New York University School of Law professor Melissa Murray, who's a leading expert in family law, constitutional law, and reproductive rights and justice. Her award-winning research focuses on the legal regulation of intimate life and encompasses such topics as the regulation of sex and sexuality, marriage and its alternatives, the marriage equality debate, the legal recognition of caregiving, and reproductive rights and justice. Her publications have appeared in the California Law Review, the Columbia Law Review, Harvard Law Review, Michigan Law Review, Pennsylvania Law Review, Virginia Law Review, and the Yale Law Journal, among others. She's an author of Cases on Reproductive Rights and Justice and a co-editor of Reproductive Rights and Justice Stories. Professor Murray is a graduate of the University of Virginia and the Yale Law School, where she was an editor of the Yale Law Journal. Following law school, she clerked for Justice Sonia Sotomayor, who was then of the U.S. Court of Appeals for the Second Circuit. And later, she clerked for Justice Stephan Underhill of the U.S. District Court for the District of Connecticut. Prior to joining the NYU faculty, Murray was a professor at UC Berkeley School of Law, where she also served as interim dean. Our moderator tonight is Loyola Law School professor Jessica Levinson. Levinson studies the law of the political process, including election law and governance issues, and her work focuses on ethics, political corruption, voting rights, campaign finance, ballot initiatives, redistricting, term limits, and state budgets. She regularly appears as a legal and political expert on television and in radio and in print, and has a weekly legal segment on the Los Angeles NPR station KCRW. She's also an op-ed contributor for NBC.com and the associate director of Loyola's Journalist Law School. Professor Levinson served as the president of the Los Angeles Ethics Commission until 2018. She's also the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. So hello and welcome, Professors Levinson and Murray.
Hello. There we go. Hi, Claudia.
Hi there.
Thank you so much for having us into the virtual Hammer Forum. And
thrilled to have you.
And thank you to everyone for being here. We're going to talk about, as Claudia said, one of the really big Supreme Court cases this term, which protected LGBTQ rights. And we're going to kind of situate the civil rights struggle for LGBTQ rights. And so I can't actually see Melissa. I just want, oh, there she is. There's Professor Murray. So what we are going to do, because we have one of the experts here, is we're going to first just call up some slides and basically make sure everyone gets on the same page for the case. And then Professor Murray and I are going to move into talking about the case. So if we could move on to the second slide, that would be great. And what we have here are actually 3 consolidated cases that came up to the Supreme Court. And so there were 3 different plaintiffs, but they all have something in common. And so again, we're talking about the recent Supreme Court case protecting LGBTQ rights in the workplace. And the way these cases came to the Supreme Court is that there were 3 different plaintiffs who suffered from workplace discrimination, specifically from termination, as a result of either the fact that they were gay or the fact that they were transgender. And you can look on the slide, there was Gerald Bostock, who was fired from his state job as a child advocate after he joined a gay softball league. There was Amy Stevens, who passed away right before the decision was announced, who was fired from her job at a Michigan funeral home when she announced that she was transitioning from being a man to being a woman. And then there was Donald Zarda, who was a diving instructor who was fired after he told one of the people that he was diving with that he was gay. And so how were these 3 plaintiffs able to be fired? Because not every state has protection for LGBTQ workers. And in fact, until last Monday, there was no federal protection. So that's the second big bullet point, which is there are only 21 states in the District of Columbia that prohibit workplace discrimination on the basis of both sexual orientation and gender identity. So if we could move on to the next slide, that'd be great. This is where, perfect. I just want to flag for Hammer Technical that I see Claudia frozen on the screen. If nobody else can see her, then no problem. So these 3 plaintiffs were fired. And then the question is, do they have a remedy in law? And the general issue here is, does an employer who fires an individual merely for being gay or transgender violate a specific federal law? What is that specific federal law? It's Title VII of the Civil Rights Act of 1964. And so what's the specific issue here? Does the Civil Rights Act that says you cannot fire people, you cannot discriminate in the workplace on account of sex, include discrimination on account of gender identity and or sexual orientation? Which means we know that federal law says you can't be fired just because you're a woman, but we didn't know if federal law said you can't be fired just because you're transgender, or you can't be fired just because you're gay. So if we could go to the next slide. This is the text of the Civil Rights Act. And so this is a statutory case. It's a case dealing with federal law. It's not a case dealing with the Constitution. And this is the text of Title VII of the Civil Rights Act, which talks about the fact that you cannot discriminate in the workplace on the basis of sex. It also includes, as we can see, race, color, religion, national origin. So let's go to the next slide, because I definitely want to get to Professor Murray. And then the punchline is what? Yes. An employer who fires an individual merely for being gay or transgender does violate the Civil Rights Act. Why? Because we're going to read that word sex broadly. We are going to say that the prohibition on workplace discrimination on account of sex includes discrimination on account of gender identity and sexual orientation. So let's take down the slides. And there we go. It's just the 2 of us now. Professor Murray, thank you again so much for being here. When Claudia and I talked about this program, I said, do you think we can get Melissa Murray? And so I'm very, very grateful that you agreed.
I'm really glad to be here. Thank you for having me.
So one of the things that actually you and I talked about, but I didn't mention, is that as this case came to the Supreme Court, there was a split between the EEOC and the Trump administration. Do you want to talk a little bit about that background before we get into the decision itself?
Sure. The Equal Employment Opportunity Commission, the EEOC, is the federal agency charged with administering Title VII and the Civil Rights Act of 1964. As many administrative agencies have a particular statute that they're charged with dealing with, and the EEOC is the one that deals with Title VII. The EEOC had actually issued guidance and a ruling stating that Title VII's prohibition of discrimination because of sex was to be read to include discrimination on the basis of gender identity and sexual orientation. So the agency itself actually came out with this particular position on these three cases. And that position was completely opposite of what the administration, the Department of Justice, did. So the Department of Justice actually came into these cases on the side of the employers, arguing that the statute should be interpreted to be just sex in terms of biological sex, not sexual orientation and not gender identity. So we had a split between these two different elements of the executive branch. The agency on the one hand arguing for a textualist reading that would interpret the word sex to include sexual orientation and gender identity, and the Department of Justice, on the other hand, representing the Trump administration and saying that indeed they only understood sex to be biological sex.
Yeah, so that really leads us to where we want to go, which is this differing approach to how narrowly or how broadly we should read this single word. And this is one of those cases where I'm sure when we were both commenting on it, it's like it's actually a very narrow issue of statutory construction, but it's one of the quote unquote blockbuster cases this term because of the huge practical implications. So you mentioned the word textualism, I think. There was an issue in this case about, again, how broadly or narrowly we want to read the word. What is a textualist approach, and why does it appear that both the majority and the dissent claim that they were taking it?
So in statutory interpretation, there are basic schools and methodologies or approaches that you can take for interpreting statutes. One school of statutory interpretation is textualism. And in a nutshell, textualism is just you look at the plain text of the statute and you apply the meaning of those words to the statute. So it doesn't matter what the drafters of the statute thought when they were doing it. It doesn't matter the broader context or the new problems that have arisen that could be encompassed by the statute. You just look at the words on the page and you apply the meaning of those words to the statute and you interpret the statute in that way. Typically, textualism is a school of interpretation that's really favored by conservatives because in most cases, it yields more narrow interpretive results. So it's favored by conservatives. And it typically is favored because it is a tool of judicial restraint. You don't think about, what other forms of discrimination the drafters might have been thinking about. You don't think about other ways that the statute could be used. You really just look at the words on the page and apply those. Textualism stands in stark contrast to another school of interpretation called Purposive Ism. And in Purposive Ism, it is a more expansive interpretation. You think about the statute and the purpose, the broad purpose for which the drafters enacted it. So with an anti-discrimination statute like Title VII, you might think about, were they thinking about all the different forms that discrimination might be able to take? And if you think about sort of like not just this particular lens in this time one, but rather all of the ways this might morph and how you can best vindicate the purpose of the statute, it might actually yield results that are more expansive and typically more progressive. And so what was unusual in this case is that you had the plaintiffs represented by some of the most progressive lawyers in the country, David Cole of the ACLU, Professor Pamela Karlan from Stanford, and the arguments they were making about statutory interpretation were straight down the middle textualist arguments. They were basically arguing that if you look at Title VII's prohibition on discrimination because of sex, then you have to interpret it to include and prohibit discrimination on the basis of sexual orientation and discrimination on the basis of gender identity, because If you fire Richard because his husband is Jason, but you wouldn't fire Christina because her husband is Jason, well, that is because of the sex of Christina or Richard, and that's discrimination on the basis of sex. If you fire Amy because she used to be John, but you would not fire John for being John, you've discriminated against Amy because of sex. And so the arguments that were put forth in favor of these plaintiffs were actually kind of conservative, very straightforward textualist arguments, not the kind of arguments that typically would yield a progressive outcome like this one. So that was sort of the irony, and indeed the kind of interesting aspect, the weirdness of this particular case. You had a very conservative logic scaffolding an outcome that really is quite progressive.
Yeah, this is one of the things that I think I spoke to the Hammer audience really briefly about after the case was argued, which is you did have this kind of topsy-turvy world where you had more progressive advocates making a very conservative argument, and then the more conservative advocates saying we should really look at congressional intent. And for all of you listening, Professor Murray just mentioned Professor Pam Karlan, who you might know because she was involved and she was one of the experts for the impeachment testimony. And if anybody is interested in amazing advocacy in front of the Supreme Court, watch Pam Karlan's oral argument. I think you can lose a case in front of the court, but I thought that was magnificent. I thought she might have won that case in front of the court.
I will stop. She totally won this case alongside David Cole. Like, this argument, I think, made the outcome possible here. I've never seen anything like it.
And you could, during oral arguments, you saw, and I mean, obviously I wasn't the only one to see this, Neil Gorsuch all of a sudden is in play. And the interesting thing was, and we didn't say this at the beginning, but I said what the conclusion was, that the answer is yes, LGBTQ workers are protected under federal law. They are protected under the Civil Rights Act. But by what vote? And we'll talk about this in a minute, but the vote was 6-3. It wasn't a typical 5-4 where you have just one conservative switch. The majority opinion is written by President Trump's first appointee, Neil Gorsuch, and it's joined by Chief Justice John Roberts, the new middle of the Supreme Court.
So I think that was perhaps the most surprising aspect of this whole case. I mean, if you watch the oral argument, which was one of the first oral arguments that the court heard, this is back in October. If you watch that, it was very clear that Neil Gorsuch, one of the newer justices on the court, was the person to whom all of the advocates were pitching. He was sort of the one justice who perhaps was in play, in part because in his jurisprudence, he has been an avowed and committed textualist. He just wrote a book, A Republic If You Can Keep It, where he extolled the virtues of textualism and adhering to the plain meaning of text as a statutory interpretation approach. And so when David Cole and Pam Karlan teed up these arguments, they were really pitching to him, right? I mean, he was sort of the person who these arguments would hit with the best reception. In the oral argument, though, it did seem like Justice Gorsuch was wobbly. He definitely understood why a textualist reading of this statute would yield the outcome that ultimately he reached, but he was also worried about some of the unintended consequences, as he put it. He talked about the possibility, perhaps, of social disruption and upheaval if Title VII was interpreted to prohibit discrimination on the basis of gender identity and sexual orientation. So there's a lot of talk of bathrooms, and even the liberal justices on the court joined in with that. But in the end, he sort of stayed straight down the middle, hewed to this textualist logic. And it's not, if I thought this case was going to come out in favor of the plaintiffs, I would have thought it would be a 5-4 decision, as you say, with Neil Gorsuch writing for the majority. But the real surprise here was that Chief Justice Roberts also came along. And I still am scratching my head about that one. That was really just out of the blue, to me at least. I don't think a lot of people saw that coming.
And I'd love to talk about this at the end, which is, what does it mean that we truly have the Roberts court now? And what does it mean that he joined this opinion. We have a good, I'm sorry, Hammer staff, I know I'm only supposed to look at the Q&A, but we have a good chat from Liz Cohen. And she said, essentially, it'd be good to hold up signs of the two schools of thought, meaning the conservative school of thought and the liberal school of thought. So I'll interject just for a second. Probably everybody in their daily life at some point has signed a contract. And it's not a direct analogy, but when you're signing the contract, you might have a discussion around the contract about what the terms really mean and what everybody intends to happen as a result of the contract. A conservative reading of a contract would ignore all of those discussions. And it's the same thing for a conservative reading of federal law. You ignore everything that happens around, you ignore any kind of chit chat about intent, and you just look at the words on the page. A more liberal reading would be, what did we all mean when we signed this contract? What did we all intend? What was our main goal here? And so that's one way of thinking about this dichotomy that we saw. Again, what's interesting is that you have all four liberal justices join in this pretty conservative textualist opinion. And thank you for responding in the chat. And so one question I had is, why do we see the liberal justices joining an opinion that looks to be a fairly conservative opinion?
Well, I think the liberal justices don't necessarily hew to any particular school of thought. Justice Kagan famously said, I think in her confirmation hearing, we are all textualists now. And I think that's actually true. Even the conservative justices sort of pick and choose different schools of interpretation for constitutional law and different schools of interpretation for statutory interpretation. So there's a lot of promiscuity in terms of their adherence to different methodologies. Here, I think, though, it was a very good argument that Pam Carlin and David Cole made. And if you read the statute according to its plain meaning, then you would yield an outcome where firing Amy because she was a man and had transitioned to a woman was about discrimination on the basis of sex. Similarly, firing someone because their husband was a man and they were a man was also discrimination on the basis of sex. So I think the outcome, regardless of whether you used a purposivist lens or a textualist lens, was one that the liberal justices of the court definitely wanted. Their whole question was, who could they convince to join them? And here they got not one, but two. And that really, I think, was the surprise.
In taking a step back for a minute, is there any argument here about congressional intent? Is there any argument that Congress maybe wanted the word sex to be read broadly in the future, or do we basically know what congressional intent was?
Well, so there's a lot of lore around Title VII and how sexual or sex discrimination came to be included in Title VII. And so as the lore goes, when this was being brought to the floor of the House for a final vote, Representative Smith, who was a representative from Virginia and a staunch opponent of any kind of civil rights legislation, offered up an amendment that would include into the bill the word sex. So not just race, not just religion and national origin, but also sex. And as the lore goes, he included this for the purpose of inserting a poison pill, essentially, into the legislation. He assumed that if you inserted sex and people now understood that this would now prevent discrimination against women, they would not vote for it. Obviously, that didn't happen. And there's lots of arguments suggesting that that's not why he included it, but that is the lore around Title VII. But it's very clear that when Title VII was being debated, they understood the term sex to be about biological sex, to be about discrimination against women. Interestingly, though, the statute has been interpreted by this court, at least in 3 other occasions, and has sort of gone beyond just the purview of discrimination against women. So, for example, in a case called Phillips versus Martin Marietta, the term discrimination because of sex was interpreted to include discrimination against mothers. So not women per se, but a particular sort of social category of womanhood, motherhood was included within that rubric. There's also another case, much more recent, from 1998, and one that was written by Justice Antonin Scalia, who prior to Justice Gorsuch was probably the standard bearer for textualism on the Supreme Court. But in this case, on Call versus Sundowner, Justice Scalia wrote an opinion interpreting Title VII's because of sex provision and interpreted it to include a prohibition on same-sex sexual harassment. So that was not something that the drafters of Title VII had contemplated in 1964. Nevertheless, Justice Scalia, in that very textualist decision, said, doesn't matter what was in their heads, all that matters is what's on the page. And if you are firing someone because they are the victim of same-sex sexual harassment, it's because of their sex, and that's discrimination on the basis of sex.
Yeah, it is fascinating how on these issues of statutory interpretation, by which we mean how you read a federal law or how you read a state law in some cases, you can't necessarily predict outcome by what you see as conservative ideology or liberal ideology. And I guess, which is another way of saying it's not always true that conservative legal thought maps directly onto conservative political thought, and vice versa. And we all have this feeling of the most important thing for the Supreme Court is just count how many justices were appointed by Republicans, count how many justices are appointed by Democrats, and we have our answer. And I think, as you just laid out, it's definitely not always true, particularly when it comes to these fairly narrow interpretation cases.
Well, it is worth noting, though, that the other side of the court, so the three justices who were in the dissent here, those were Justices Alito, Thomas, and Kavanaugh. At least Justice Alito seemed to be quite vexed about this direction that conservatism had taken in terms of its textualist approach. And it seemed like on both sides of the court, there was sort of a shadow boxing with the ghost of Justice Scalia and who would actually be the true heir of Justice Scalia. And you had Justice Gorsuch sort of announcing himself as a true textualist with this interpretation of the statute. And then Justice Alito, who wrote a 100-page dissent. I mean, a dissent that actually broke the court's website the day it was announced. It was so huge, broke the website. And it was a really fiery, vehement, and angry dissent. And one of the things I think he was quite angry about was this isn't an outcome that Justice Scalia would have reached. Justice Scalia was a committed textualist, but not where, as Justice Alito says, it would lead to absurd results. And in his view, interpreting because of sex to lead to Title VII, including sexual orientation and gender identity, was so far afield from what was intended in 1964, it was an actual absurd result and should not be tolerated.
So I love that image of the shadow boxing, and the prize is will the real textualist please stand up, basically. Will you give us some, so I just want to make sure that, as I do in a law school class, kind of we're all in the same place. So we talked about the people who sued, we talked about the law that was at issue, we talked about the oral advocates and what the arguments were on both sides on this issue of what is discrimination on the basis of sex really mean. And then we talked about the two main schools of thought when it comes to legal interpretation. And then we get to this place of what did Congress intend? We know that Congress wasn't really thinking about protecting people who were gay or who were transgender.
We don't know, right? I think it's probably likely that they did not imagine that they would be protecting gay men and women and transgender women. They didn't even know from transgender in 1964. So, they couldn't have thought that. But as the majority opinion notes, in the 5 years right after Title VII was passed, there were already claims being filed by gay men and women for protection. So even if the drafters didn't understand because of sex to mean that, the language of the statute had already sort of seeded in certain groups that there might be the possibility of protection for them as well. And that kind of speaks, I think, to the plain meaning of the statute.
And that's how, in some cases, we were acting. We assumed that it did, like the EEOC, we assumed that it was that broader reading. So
Well, it's actually not a broad reading. I mean, that's the thing I would push back on. When you say discrimination because of sex, and you talk about Richard, who's married to Jason, and he's fired, and Cindy, who's married to Jason, is not fired, it's not a broad reading at all. It's actually a reading about because of sex. Richard's fired because he's a man married to a man.
Yeah, well, I guess I should have said broader than just biological sex.
Well, it's still biological sex. Richard is biologically a man. I mean, maybe in the transgender circumstance, like it's more expansive a reading of because of sex, because it's not hewing to biological sex particularly, although you could make that argument that it is. But it's actually, the logic of the opinion is not far out at all. It's actually a very sort of cabined and tight argument that's really about you're discriminating because of someone's gender. Like, they're not the right gender. If you were going to be married to Richard, you needed to be Cindy, and you're not.
Okay, I like these moments where I learned something and I changed my mind. So let's focus on that argument. So you said the majority is actually a pretty cabined argument. What are your main takeaways from the majority opinion?
So let me reference the question that Yuvraj, hi Yuvraj, says in the chat here. So the question he asks is, does it matter that Bostock is a dry textualist opinion rather than a poetic social meaning opinion? And the exemplar of the poetic social meaning opinion is Obergefell versus Hodges, the 2015 opinion legalizing same-sex marriage, where Justice Kennedy waxed lyrical about dignity for hours and hours in that decision. Hold on, a child is coming into the frame.
What's the Wi-Fi password?
You've got to go ask Daddy about that.
He just told me to ask you.
Tell him I'm on a call.
But he's on a call.
Then you'll have to wait.
Can you just do it? It's easy.
I told you that.
I'm just gonna do a quick interpretive dance while you do that. No problem at all.
Okay.
What I'm gonna do is silently mime what textualism looks like. And then I'm gonna silently mime what Purposism looks like.
I'm hoping this is the right password for the Wi-Fi.
Well, no, I think everybody's learning a lot from this particular moment. So what I wanted to get to, though, for the majority opinion is that you do have this really tight, really to the point opinion, which says essentially exactly what you said, that of course that this is the correct reading. Of course that if you are firing somebody because they're a man married to a man, and you wouldn't have fired them because they're a woman married to a man, then it's on the basis of sex. Of course, if you're firing somebody because they are John who became Amy, then it's on the basis of sex. You didn't want to share your Wi-Fi password with the audience?
I can't remember it. I actually can't remember it. So I just gave him my phone. I toggled him to my phone. My data bill will now be like $1 million by the end of the evening.
Just do what I do and have that little napkin of every password that you've ever written just right next to you. And so
back to Obergefell and dignity and Yuvraj's question. I actually don't think that this is a dry textualist opinion. There are actually glimmers, I think, of important language that I think advocates can really make use of going forward. It is not the kind of lofty, soaring opinion that we would have gotten from someone like Justice Kennedy. But on the other hand, I think advocates were often left with a Justice Kennedy opinion where they sort of threw their hands up, like, we got the right outcome, but I don't know how to actually litigate with this. Justice Kennedy was not always great about offering clear analytical lines to follow. This actually does. And to some degree, there's some language here, I think, in the opinion that might support a reading of including sexual orientation and maybe even gender identity within the group of quasi-suspect classes that are entitled to more searching judicial review in the constitutional context. So yes, I think the question is exactly right. This is not the kind of dignity-infused decision that we saw in Obergefell. I still think it's a really important decision. It may be the most important gay rights decision of the last 50 years. And you can fight me on that one if you want to. I'm happy to explain myself. But I think there's a lot of stuff here that advocates can use going forward.
So I actually tend to agree on this, which is I think that Obergefell, which is the decision saying that there's a fundamental right to marriage that's shared for both heterosexual couples and same-sex couples, is enormously important, and we shouldn't take anything away from that, and was, I think, psychologically and emotionally a huge sea change. In terms of people's daily lives, in terms of financial protections, in terms of workplace protections, could we make an argument that this kind of little case of what does the word sex mean, and I'll no longer say should we read it broadly or narrowly, but this little case about what should we read the word sex to mean, could it actually have a greater impact on people's daily lives?
So I said this maybe on MSNBC, and I got like a slew of sort of angry mail from people, and I want to be really clear in saying this. I do think this is a more important opinion than Obergefell versus Hodges. And I say that, I don't mean to denigrate same-sex marriage in any way. I mean, I understand that for many people, the opportunity to formally be recognized as a couple was enormous for families, enormous just for the dignity of your couplehood. I totally get that. But I just want to sort of mark that there are a lot of adults who are not married, who will never get married, whether gay or straight. I think almost every adult has to, at some point in their adult lives, have a job. And to be discriminated against because you got married on Sunday and your boss finds out about it, because you're Richard and you married John, that's such an enormous amount of economic insecurity to deal with on a regular basis that I do think having that taken off the table is enormously valuable for individuals. I think it's even more profound. We're living in this period of, global public health crisis. And for most of us, our health coverage, our health insurance is completely tied to our employment. So to be secure in your employment, I think is as important, and maybe in this moment, even more important than the security of having your families recognized, especially for people who already aren't married, but economic security is important for them. So this is not to denigrate Obergefell in any way. I do think, though, that this opinion gives more in terms of its logic, offers more that can be used going forward, and honestly is a enormous practical import to more people than perhaps Obergefell was.
Obergefell, again, the opinion talking about a fundamental right to marriage for everyone, felt to me like it was just an incredibly warm embrace from now retired Justice Anthony Kennedy. You could kind of feel him crying a little bit when he wrote the opinion. It was very moving. This one feels very sanitized and kind of clinical and cold, but with enormous implications, as you said. And so I think I would rather take the, short and to the point protection than, the Justice Kennedy, here's the result. And in some cases, in my opinion, kind of, and here's a feel good haiku.
Well, so I wonder, I don't know that. I mean, I think it is clinical. I don't know that it's cold necessarily. I mean, there's this really interesting part of the opinion where, Justice Gorsuch talks about the reach of Title VII, and is it true that Richard has a husband, or that Amy was Richard and became a woman? Title VII doesn't care. That's what he says. I mean, and that actually is really interesting. It doesn't matter what the circumstances of LGBTQ plus lives are. Title VII doesn't care. It includes them anyway. It doesn't matter. And I don't think we've ever had such a profound just embrace of LGBTQ persons, even in the marriage context until now.
So, I mean, we have never had a decision supporting gay rights that was not written by a man named Justice Anthony Kennedy. Yes. And that in and of itself is absolutely extraordinary, because when Justice Kennedy retired, what feels like about 18 years ago, but was probably 2 at this point.
I mean, it's been a long 2 years.
Yeah, it's been it's been a dog year of the 2 years. One of the big questions was what happens to the issues where he's the swing vote: affirmative action, death penalty, gay rights, and reproductive rights. Yeah. And so, this at least gives us some insight when it comes to not the constitutional cases, but at least to the cases dealing with federal law. But then the question I had is, does it give us, you talked about this a little bit, and I'd like to tease it out a little more. Does it give us some indication of where the court's going in terms of the big constitutional cases for the LGBT community? The equal protection issue obviously is looming very large.
All right, so there's a question in the chat from Cameron and another from Benoit that let me just address. This whole question, and this was something that the dissents raised repeatedly, both Justice Kavanaugh and Justice Alito, their point was that if this was the interpretation that Congress wanted, Congress should have done it. And of course, Congress has not been able to do it. There's been an ENDA pending in Congress for I don't know how many years, and they've never actually, even when the Democrats controlled both chambers, ever managed to pass and include a prohibition on discrimination on the basis of sexual orientation and gender identity in Title VII. Now they don't have to, but maybe they should, just to clarify and to make those gains truly clear. But they weren't able to do that. What does it mean going forward that this is, I think, a very contested decision, certainly from the right? I mean, we saw the conservative legal movement like completely decompose on Twitter last Monday. I want to be really clear about this. I don't think this is the moment to invite Neil Gorsuch to be the Grand Marshal of the Gay Pride Parade, and the way that I think Justice Kennedy was the Gay Marshal of the Gay Pride Parade on one year, at least. At the end of the opinion, he notes that there are still questions of religious accommodation and religious freedom that are still out there. And those are to be handled at a later date. And he notes that Title VII already has protections for religious employers. And in fact, right now, the court is actually hearing 2 cases about Title VII's exemption for religious institutions. These are the ministerial exemption cases that should come down within weeks. Those could further limit the reach of this. In addition, he noted that the Religious Freedom Restoration Act, which is a law that, again, protects religious freedom, might function as a quote unquote super statute here that would override Title VII entirely and provide the basis for broad accommodations of those who either because of religion or simply because of moral conscience, as the Trump administration has interpreted it, don't agree with same-sex unions, same-sex partnerships, or transgender identity. So I think we still have a road to go, and it's not clear where the conservative wing of the court stands on that. I think what is clear, and as you've alluded to, Justice Roberts is at the center of the court now. But to be clear, if he's at the center, this is not the center of the court that we knew with Anthony Kennedy. It really means that the court has very much lurched to the right if he's at the center of it.
Yeah, I mean, this is one of the things that we've been talking about on these Hammer forums, which is, the center of the court is here, and then it's just the sands kind of shift beneath the court. And I apologize. I think I've said this to this audience before, but I remember when Justice Ginsburg was nominated, the headline was President Clinton nominates moderate jurist. And now she's known as, arguably the more liberal side of the liberal wing.
Well, there's a lot of research and empirical work that's been done by Lee Epstein and Andrew Martin and Kevin Quinn, who've argued that as justices get older, they do tend to drift to the left a little bit. Harry Blackmun was a great example of this. Just John Paul Stevens was a great example of this. But it also is the case that the court has gotten more conservative. And I think people may find that to be sort of perhaps shocking, illuminating. But let me just say, if you thought the court was a liberal institution, you missed most of the court's history. I mean, the court's really only been liberal for its sort of sliver in the Warren Court and Burger Court eras, and only on certain questions. For most of its history, the court's been a very conservative institution, and really at loggerheads with Congress in trying to get to progressive outcomes. I mean, Reconstruction is a perfect example in the Gilded Age of all of this.
I'm trying to spare everyone the analogy of a graph and a curve, because I know that we've all been inundated by that. But I mean, you're absolutely right. When you think about conservative court, you have a moment of liberal court, conservative court, you have a moment of liberal court. But it's, the court has hardly been a consistently liberal institution. And one of the things that, speaking of people who are not liberal, this is going to be a strange transition. Let's talk about Justice Samuel Alito for a moment. And you mentioned this, but I do want to get out before we're done, and a big takeaways from majority, which I think that we've largely covered, and then big takeaways from the dissent. And as you said, it was very long. It was very impassioned. Is it a logical textualist reading? Is this just a matter of a different school of thought for how we look at this word? Or do we think that there's something else going on more broadly?
So I do think that the two opinions are sort of a battle over what does it mean to be a good textualist. And, like I've said, what does it mean to be the heir of Antonin Scalia? I think that Justice Alito would say that it would not be good textualism to interpret the plain meaning of a statute in a way that would be absolutely absurd to the drafters. Like, leaving aside that you're not supposed to take into account what they had in their minds or what they intended, the purpose shouldn't matter. But if the results are so absurd, they really shouldn't matter. That can't be the right outcome. I mean, so he talks about this as the donut hole exception, or the elephant in a mouse hole. I mean, if the result would be that an elephant is now in the mouse hole, threatening to sort of, upend the entire statute, that can't be the result that textualism leads to. But I think in a larger sense, his anger and he's exercised, I think, about what does it mean to be a conservative court? I mean, so for at least the last 2 years, certainly with the addition of Brett Kavanaugh, there's been all of this discussion, like now we have a truly conservative majority on the court. We're going to see some stuff. I think it's why everyone is so surprised and so jubilant about this outcome. But I think for him, it was like, come on, guys, we're supposed to be conservatives. This isn't like an outcome that leads to recognizing sexual orientation and gender identity as part of a statute that was written in 1964. That's not conservative. Conservatism is about restraint. And this is not that. So I think it is about, what does textualism mean? But I think more fundamentally, it is about what does it mean to be a conservative court? What does it mean to be a bulwark against the sort of wokeness of the polity?
And this is back to the legal ideology versus political ideology. This is back to the how much of judging, particularly on the Supreme Court, is really about getting to a certain outcome and just saying, I'm the true textualist. No, I'm the true textualist. When I think we could all say, or at least I could say, I don't think there was a world in which Samuel Alito was ever going to join this opinion. But there's somebody else who didn't join Samuel Alito's opinion. And I think we mentioned this briefly, but Justice Brett Kavanaugh dissented. He did not join the majority in saying that LGBT workers should be protected, but he didn't join Justice Alito's very impassioned, somewhat fiery, very lengthy dissent. So what do we make of the fact that we have one Trump appointee writing majority opinion and another Trump appointee dissenting, but not joining the really impassioned, really long dissent?
to occupy the mind of any of these people, I think is just, way above my pay grade. I think it was interesting because Justice Kavanaugh's own separate dissent was obviously not as long as Justice Alito's few could be, but it was also different in tone, right? So, I mean, he started that opinion by congratulating the LGBTQ community on a victory, and he like, you should celebrate. And in that way, it was very much like Chief Justice Roberts's dissent from Obergefell, where he notes toward the end, this is a victory for the LGBTQ community. You should celebrate, but don't celebrate the Constitution. It had nothing to do with this. This was really the work of activist judges. And Kavanaugh's opinion was sort of in that vein, like, congrats, this is not judicial restraint. And, so it did echo some of Alito's, but I think without the vitriol and the anger, and with, a nod that you will likely be very encouraged by this if you're a member of this community or you're someone who wants to see Title VII interpreted in this way. And, so celebrate, but this is not judicial restraint.
And it does feel like there have been a few instances where we've seen Justice Kavanaugh agree with a conservative result, but write separately just to let everybody know that he still cares about you. He's not about, essentially the way I read it is sometimes, I'm not an angry person. I'm not a partisan hack. I'm writing this because of certain legal philosophy that I have, but don't take this to mean anything about my partisan ideology and that I'm bringing it to the court.
Yeah, I think it's a terrific point. I mean, I don't know how much work has been done on, whether and how the confirmation battle shapes one's performance as a justice. But, I think the two most contentious confirmation battles, at least of my lifetime, were Justice Thomas's and Justice Kavanaugh's. And, maybe this is a response to what happened during his confirmation hearing and his own performance before the Senate Judiciary Committee. And he wants to make clear, I'm not angry, I can be conciliatory, but I still have principles. And I think there's been a lot of ink spilled on the way in which, perhaps Justice Thomas's reticence, he rarely asked questions from the bench, is a response to feeling very put on the spot during his confirmation hearing back in 1991.
We did hear a great deal from Justice Thomas once everything happened over the phone. So as the Hammer audience knows, when the Supreme Court moved to oral arguments over the phone in May, I collectively felt when I was on the conference call with the justices, like Chief Justice John Roberts was going to say, Justice Thomas, and it was just going to be dead air for a minute, and you'd hear some sort of pass. And instead, he was very active. I thought he set the tone for a lot of the oral arguments. I thought that he asked very probing questions. So this kind of leads into Perry's question that I want to be sure we get to because I see that it's 5:55, which is, does this decision, along with the DACA decision, and let me just advertise for everybody on, we're going to be doing a Hammer Forum on DACA on Wednesday, July 1st, same time, 5 p.m. And that will be up on the Hammer website soon. So does this decision, along with the DACA decision and some other decisions from this session of the court, cause you to reconsider what long-term impact of the court on the court's direction will be of Justices Kavanaugh and Gorsuch?
I think it's really too early to tell. Like I said, I don't think this means that Justice Gorsuch is going to be like Justice Kennedy and that he will be reliably in favor of LGBTQ rights going forward. I don't know that will be true. Likewise for Justice Kavanaugh, I don't know. We're going to get more decisions. It feels like this should be the end of the term, but we had that huge hiatus between the March sitting and when arguments resumed via telephone in May. And so we're actually about a month behind. So this is ordinarily the time where we're winding down and taking stock of the perm in the court. But in fact, we're really only halfway done. And there's some big cases that are still to come out. June Medical, which is about abortion. There are the two ministerial exemption cases. There's a case Espinosa about state funding for religious institutions. And then, of course, the suite of Trump financial disclosure cases. So I think we will have more fodder to sort of think about the direction of the court as those decisions are issued.
Yeah, in a really interesting case dealing with faithless electors, which obviously has huge political implications, but it is again interesting, one of those interpretation questions, but in that case based on like the Constitution. So I can't believe it, because we got through about 28% of my questions, but I think we're nearing an end here. So I do want to actually end with something that you already mentioned a little bit, but I wanted to highlight it for everyone, which is that let's take a step back and think more broadly about LGBTQ rights. We talked a little bit about where we've come in terms of, we mentioned the Obergefell decision, was the same-sex marriage decision. This is one of the big cases following Obergefell when it comes to LGBTQ rights. And this is obviously, we're talking about freedom from workplace discrimination. One thing we should probably flag is, just because you have this right does not mean it's easy to win these cases.
Right. Yeah.
And do you want to pick up on that for a moment?
Sure. I mean, like, again, like a lot of this really just depends on the posture of a case. I will note, in all three of these cases, the question was whether they could even bring a claim under Title VII, not whether they could actually win the claim once it was brought. It's just whether Title VII would even recognize the discrimination that they were claiming. It seems clear that, at least in the case of Amy Stevens, who very clearly was fired because she transitioned, that there was discrimination because of sex under this interpretation of Title VII. In terms of Gerald Bostock, who was fired from his job in Clayton County, Georgia, and Donald Zarda, who was fired from his skydiving job, there are real questions about whether or not they were fired because they were gay, right? And so Title VII only allows relief and a remedy if it's actually proven that you were fired because of sex discrimination, whether sexual orientation discrimination, gender discrimination, or gender identity discrimination. So there would have to be a trial now to actually determine whether or not the employer's decision was because of sex. That means that, you know, there are lots of circumstances where employers will say, you know, I did fire Gerald, but it's not because he's gay, it's because he's terrible at the paperwork. And then you have to sort of sift through, well, was it because of the paperwork, or was it because Gerald's gay? And it actually leaves a lot of room for employers to fire people on pretextual reasons, like even if the real reason is because they're gay, and you can't ever prove it. So this is a huge step forward, certainly in terms of what the law will recognize. And there's lots of room in this interpretation to then take it to other statutory contexts and expand the protections available in other statutes. This is to Molly's point. But in terms of actually litigating on the ground, it doesn't make it easier to prove your case unless your case is very straightforward.
Right. It means you get to walk in the door and say, this is my legal theory, but you're now, the LGBT community is now in the same place as women, people of color who've tried to sue for workplace discrimination, which is saying, I know I was fired for this reason. And an employer who says exactly what you said, you were late that time, you didn't show up to this meeting. And so these are often difficult cases to prove. But the last thing I wanted to do, which is just to ask you to reiterate briefly something you already said, which is, what are the big LGBTQ issues coming up that we should, and it doesn't have to be exhaustive, I know there's an enormous amount of them, but what are the big issues? We talked a little bit about the clash between religious freedoms and freedom from discrimination, but what's in our short-term horizon?
Right. So I think a lot of it is around religious freedom. So there are two sets of cases pending before the court right now. The ministerial exemption cases, which I briefly talked about, which would provide a sort of broader exemption from the scope of Title VII for religious employers. And the question there is really like, what counts as a minister? Like, is it the janitor? Is it the IT person? Or do you actually have to be clergy? And so sort of understanding the contours of that exemption is what those cases are about. There's also another case that's not about LGBTQ rights specifically. but about the Affordable Care Act. And this case, which is called Trump versus Pennsylvania, is about the religious accommodation process, the process by which religious institutions can get an accommodation from the contraceptive mandate. If the administration wins on this particular claim, it will make it a lot easier for religious employers to claim accommodations from the scope of the ACA, and would, I think, allow them to sort of expand the terrain of how conscience exemptions and religious exemptions are doled out in ways that could be really detrimental to the LGBTQ community. And with that in mind, there's a case that's already teed up for the docket for the next term, October term 2020, called Fulton versus City of Philadelphia, in which foster parents and Catholic Social Services in Philadelphia is suing the city of Philadelphia because the city of Philadelphia has refused to extend foster care placement contracts to Catholic services or to certain foster parents because they will not accept LGBTQ persons and same-sex couples as foster parents. So again, another case that really sort of links this question of religious liberty versus LGBTQ equality.
To me, that's the looming clash. It's this, freedom of religion, freedom from discrimination.
And the last time we saw it was Masterpiece Cake Shop, where Justice Kennedy wrote that amazing punt, never really resolved the question in Masterpiece Cake Shop definitively, and then 2 days later retired from the court.
So do you want to just briefly explain Masterpiece Cake Shop was about a same-sex couple who, do you want to take it?
This is a same-sex couple, Craig and Mullins. One is Charlie, I can't recall the other one's name, but they sought a cake to commemorate their Massachusetts wedding, and they were denied the cake by Jack Phillips, who was the owner of the Masterpiece Cake Shop in Lakewood, Colorado. And so the question before the court was whether the making of the cake was expressive, was it speech, was it, was it an artistic expression such that to be required to make it, as Colorado's anti-discrimination statute required of all places of public accommodation, whether it actually provided for an accommodation for Jack Phillips, or whether it compelled Jack Phillips to make a statement about same-sex marriage that his religion and his conscience was uncomfortable with. So again, the clash of anti-discrimination law with the question of religious liberty.
So with that, I'm getting increasingly concerned about your data package. So
I'm going to just send the bill to the Hammer Museum. It'll be $1 million by the time he's done with it, I'm sure.
Just tell us what he watched. That's what, if later we'll do a follow-up.
It's something on Disney Plus. I don't even know. It's like, all of these shows like Bunked, like all of these kid shows that are just like terrible to watch all the time. Like it's better for him to watch it by himself. But in order to do that, he needs the Wi-Fi passwords, as you saw.
I understand this very well. So I want to say, first, I saw a couple of students, Loyola students. So Cameron and Molly, thanks for your questions. I'm really glad that you guys signed on. And I also want to really apologize for everyone that you had to see me hand dancing. It was kind of the best that I could think of at that particular moment. If you want to edit it out later, Hammer form, that's totally fine. I want to thank Professor Murray so much. I really enjoyed this conversation. And with that, I think that we are going to be played off. Bye, everybody.